Hello, and welcome to another episode of What Nobody Told Me After 65. Well, it's the lady on the go, lady in the know, Miss Info. And this is the Information Nation, where knowledge is shared and wisdom exchanged for the betterment of a people. Part 2, Bankruptcy. That's what we're talking about. The day before yesterday, I gave you information on Chapter 7. We're going to talk about Chapter 11 and wind it up with Chapter 13. Chapter 13 is the one that I'm most familiar with because, as I told you, I did file Chapter 13 many years ago. But just to recap, what is bankruptcy? It is a legal process through which people or other entities who cannot repay their debts to their creditors may seek relief from some or all of their debts. Usually, in most jurisdictions, bankruptcy is imposed by a court order, often initiated by the debtor. Bankruptcy is not the only legal status that is an insolvent person may have. Basically, bankruptcy is your last resort. If you can do anything else, if you can get in a repayment plan, if you can get in with one of those debt relief companies, if you can get in one of those, then maybe bankruptcy may not be for you. But in a nutshell, bankruptcy is a legal way for you to discharge your debts and under the protection of the U.S. Bankruptcy Court. And there's no shame in it at all. So, let me talk to you about Chapter 11. A case filed under Chapter 11 of the United States Bankruptcy Code is frequently referred to as reorganization bankruptcy. Usually, the debtor remains in possession and has powers and duties of a trustee. They may continue to operate in business and may, with court approval, borrow new money. That's why most of the time Chapter 11 or reorganization is reserved for businesses. But if you're a small business, maybe this will work for you. A plan of reorganization is proposed. Creditors whose rights are affected may vote on the plan, and the plan may be confirmed by the court if it gets the required votes and if it satisfies certain legal requirements. Now, how does Chapter 11 work? I'm really going to have to read this because I'm not sure. A Chapter 11 case begins with the filing of a petition with the bankruptcy court. Wherever you're living at, that's where the jurisdiction is. A petition may be a voluntary petition, which is filed by the debtor, or it may be an involuntary petition filed by creditors that meet certain requirements. A voluntary petition must adhere to the format of the official forms. There's a lot of forms that gets filled out. That's why you need a lawyer. And the debtor must also file with the court these following items. Excuse me. Schedules of assets and liabilities, what you owe and how much money you have. A schedule of current income and expenditures. A schedule of executory contracts and unexpired leases, and a statement of your financial affairs from your bank or an accountant. If the debtor is an individual or a married couple filing jointly, there are additional document requirements. These debtors must file a certificate of credit counseling. That's going to be necessary in all three of these chapters. You're going to have credit counseling. And a copy of any debt repayment plan developed through credit counseling. evidence of payment from employers, if any, that was received 60 days before the filing, a statement of your monthly net income and any anticipated increase in income or expenses after filing, and a record of any interest the debtor has in federal or state qualified education or tuition accounts. An individual cannot file Chapter 11 or any other chapter if during the preceding 180 days a prior bankruptcy petition was dismissed due to the debtor's willful failure to appear before the court or to comply with the court orders, or if it was voluntarily dismissed after creditors sought relief from the bankruptcy court to recover property upon which they held liens. In addition, no individual may be a debtor under Chapter 11 or any chapter of the Bankruptcy Code unless he or she has, within 180 days before filing, received credit counseling from an approved credit counseling agency, either in an individual or group setting. There are exceptions in emergency situations or where the U.S. trustee or the bankruptcy administrator has determined that there are insufficient approved agencies to provide the required counseling. If a debt management plan is developed during required credit counseling, it must be filed with the court. Now here's some fees. The courts are required to charge a $1,167 case filing fee, and a $571 miscellaneous administrative fee. The fees must be paid to the clerk of the court upon filing, or may, with the court's permission, be paid by individual debtors in installments. So if you're an individual debtor seeking Chapter 11 reorganization, you might be able to get in a payment plan. If you are a business, you cannot. Bankruptcy Court Miscellaneous Fee Schedule, Item 8, limits to 4 the number of installments for the filing fee. So that $1,500, $1,600, $1,700, you can do it in 4 installments, nothing more. Maybe you can do it less in 2 installments, but 4 is the maximum number. The final installment must be paid not later than 120 days after filing the petition. The court may extend the time of any installment provided that the last installment is paid not later than 100 days after the filing of the petition. If a joint petition is filed, only 1 filing fee and 1 admin fee are charged. Debtors should be aware that failure to pay these fees may result in dismissal of the case. Remember, dismissal means you've been kicked out. Discharge means you paid and you followed all the rules. The voluntary petition will include standard information concerning the debtor's name, social security number, or tax identification number, residence, location of principal assets, if a business, the debtor's plan or intention to file a plan, and a request for relief under the appropriate chapter of the Bankruptcy Code. Upon filing a voluntary petition for relief under Chapter 11, or in an involuntary case, the entry of an order for relief, the debtor automatically assumes an additional identity as the debtor in possession. And it's in quotes, debtor in possession. And again, that just means that you've kept your business and you're going to continue to operate. A debtor will remain a debtor in possession until the debtor's plan of reorganization is confirmed. The debtor's case is dismissed or converted to Chapter 7, or the Chapter 11 trustee is appointed. The appointment or election of a trustee occurs only in a small number of cases. Generally, the debtor, as debtor in possession, operates the business and performs many of the functions that a trustee performs in cases under other chapters. In a nutshell, they're just saying, typically in a Chapter 11, you don't get assigned a trustee who makes sure you follow the plan, make sure the creditors have been notified, make sure that there's money in the account. Under Chapter 11, the debtor who remains in possession of their business, they've got money coming in. That's their responsibility. You got to keep good records. Generally, a written disclosure statement and a plan of reorganization must be filed with the court. The disclosure statement is a document that must contain information concerning the assets, liabilities, and business affairs of the debtor, sufficient to enable a creditor to make an informed judgment about the debtor's plan of reorganization. Remember, your creditors are reading this plan that you are putting together. If they do not agree, you may not be able to file a Chapter 11. You might have to do a 7 or something else. Creditors whose claims are impaired, for example, those whose contractual rights are to be modified or who will be paid less than the full value of their claims under the plan, vote on the plan by ballot. This is serious business. After the disclosure statement is approved by the court and the ballots are collected and tallied, the court will conduct a confirmation hearing to determine whether to confirm the plan under Chapter 11. In the case of individuals, Chapter 11 bears some similarities to Chapter 13. For example, property of the estate for an individual debtor includes the debtor's earnings and property acquired by the debtor after filing until the case is closed, dismissed, or converted. Funding of the plan may be from the debtor's future earnings, and the plan cannot be confirmed over a creditor's objection without committing all of the debtor's disposable income over 5 years, unless the plan pays the claim in full with interest over a shorter period of time. Now, that's a lot to take in, and that's why I said you can't take this lightly, but you need to take it seriously and you need to act quickly. If you are a small business owner or a medium-sized business owner, you might want to consider a Chapter 11 to get relief. You remain in control of your business and you can still operate, so they're assuming you're going to be making money so that you can pay these people back that you owe. I'm not going to go over Chapter 13 tonight. I am going to reserve that for tomorrow, so this ends up being a 3-part series. I do want to give you a little background information on bankruptcy, basically because you need to get comfortable with it. Even if you don't use it now, maybe you intend to use it down the road, and it's just good information, if you will. In ancient times, bankruptcy did not exist. If a man owed and he could not pay, he and his wife, children or servants, were forced into debt slavery. I think years ago my grandmother told me something about debtor's prison, the workhouse, the poorhouse. She told me a story one time about a man going to the poorhouse. And of course, they give him a barrel to push. And he's pushing the barrel along, and of course he's not a bad looking guy, and the women are coming out. Where you heading? Where you taking that fine man? Where's he going? And of course he was being accompanied by a guard. And he said, he's going to debtor's prison. He's going to the workhouse. And he said, well, I got some meal here, and some cornmeal and a little slab of bacon I could give him, and he might be able to get some strength and get to working. And he said, well, are you going to turn that meal into bread? And the lady said, no. And he said, let's keep going. And he went on, and the story ends that after all these people are offering him, some bricks so that he could maybe go and build something and sell it, and he didn't take none of that. He ended up turning that barrel over upside down so nobody could put nothing in it, and said, take me on to prison. I'd rather go there. That's not a good idea. That's why we now have bankruptcy. But just think, it didn't used to exist. And in ancient Greece, they put the mom, the dad, the servants, the children, everybody went to debtor's prison. So bankruptcy, the first statute of bankruptcy under English law was established in 1542. That's a long time ago. And it was a law that dealt with bankruptcy or insolvency. And they also had bankruptcy in East Asia. But they had a provision, that was under Genghis Khan. They had a provision that if you filed for bankruptcy more than 3 times, you were put to death. Wow. At any rate, in modern times, bankruptcy is to help eliminate debt. That's what it's there for. It's a constitutional right, and it is there for your protection. You're under the bankruptcy court's protection. No harm, no foul. If you need it, use it. If you don't need it, good. At least you'll have an understanding of how you can explain it to a loved one, a child, a grandchild, a friend, a neighbor, a colleague. It's good information, and it's good to share. That's what we do here. Information Nation, we share. I think I had mentioned to you that there is a membership button if you're interested. Again, something that YouTube puts on your page if you're interested. Check it out. I think it's $3 a month, $6 a month. And you get some perks. You get just a little bit more of me and my mouth and my wisdom, so to speak. I want to thank you so much for sharing this time with me. I'm still working on the platform for t-shirts. And like I said, we're going somewhere. I can see us having some meetups, some meet and greets in different areas, different locations of the country. I can see us getting together and going on maybe a trip, a tour, a information conference. I don't know. Sky's the limit. We're going to have fun getting there, right? If you want to leave me a comment, make a suggestion, I'm all ears. Leave me a comment, leave me a suggestion, and remember, you don't know what you don't know. Thanks for listening.